Chuck, thank you so much for coming on the program. Great talking to you.
Always good to be on, Cam.
So we saw on Monday Federal Judge Richard Seaborg ruling on a case out of San Francisco that you were involved with, I believe, yes?
Oh, yes. This is an NRA CRPA Foundation legal action project joint case. So CRPA Foundation is among the plaintiffs, as are a number of San Francisco citizens who don't want to have the local government telling them how they have to store their firearms at home.
Yeah, this was a challenge to the city's storage requirement law that requires firearms to be locked up or use trigger locks at home, and then a ban on frangible ammunition as well, right?
Well, any quote-unquote non-sporting ammunition, which is interesting. So, yeah, the one ordinance requires you essentially, unless you put your gun in a locked safe, and I don't know if you remember how Justice Roberts and Scalia reacted to that when they were hearing the Heller oral argument.
I do indeed.
You got to get up, put your glasses on, turn the lights on. You know, the glass is breaking as the guy breaks in, but you have to fumble around and try and unlock some device in the middle of the night. We all know how impractical that is. Your alternative is, and the city actually said this in its brief, is that you can wear the gun in a holster and sleep with it on you in the holster while you sleep. Which I don't know about your wife, but my wife's not going to like that very much.
Yeah.
But so it's a ridiculous law. And then the other law bans the sale of anything that's non-sporting, ignoring all the rules of overpenetration and how somebody could get hurt if you use a bullet, ammunition with a bullet that doesn't stop inside the bad guy.
Right.
So that's all, plus P's, magnums, hollow points, anything like that is banned for sale in the city of San Francisco by this ordinance. And interestingly enough, the judge in his ruling said, well, they can go someplace else in another city and buy it, that's kind of con law 101, that's saying that, well, we're going to do something unconstitutional, but you can get the stuff someplace else, so it doesn't matter that we're doing that. That won't fly. They tried to argue that in the city of Chicago tried to argue that in the Ezell case, and they got smacked down pretty quickly. But this judge I think he didn't care. He knew he was going up on appeal. He knew that there's, unfortunately, many courts across the country are taking the position that a very strict and restrictive CCW license to carry regulatory schemes are constitutional, and that the standard of review they're using is just not very it doesn't put much scrutiny on the government's actions.
Absolutely, and to that end, Chuck, it seems to me like a lot of these judges are in essence saying, well, Heller didn't address this, McDonald didn't address this, and so therefore we're going to presume that anything the state wants to do is going to be okay. And we'll just sort of let the Supreme Court tell us if we're wrong. Am I reading that incorrectly?
Yes. I mean, they're bending over back. Well, there are three judges, Sykes in Seventh Circuit, the dissenting judge in Heller 2, whose name escapes me at the moment, and the judge in Woolard, in the Woolard case in Maryland. Three judges get it. Out of all the judges that have been dealing, with the Second Amendment post Heller and McDonald. And they're all bending over backwards, except for those three, to read Heller to basically allow anything. So really it is going to be up to the Supreme Court to set things straight, to confirm or deny, depending on who's on that court when the case gets in front of it, that the Heller court meant what it said and that it's not a second-class right. And that these kinds of laws that infringe on it are unconstitutional.
Yeah, to that end, I mean, I know you're not in the habit of trying to predict the Supreme Court, but I mean, we have a number of cases out there. It certainly seems to me like we're going to see some splits in the circuit courts. I mean, you mentioned the decision in Maryland. That was, of course, at the trial judge level, but that's now up on appeal in Richmond.
Right.
When do you
I don't think we're going to see a split coming out of Maryland, unfortunately.
Really?
I'm not sure we're really going to see a split coming out of anywhere. But I think the Supreme Court will still have to take one of these cases because basically these courts are thumbing their nose at the Supreme Court. And they're saying, if this is what you meant, then you're going to have to say it. They're inviting the Supreme Court to review it. Now, we could still get a split. We could still get a decision out of the Seventh Circuit. There's a couple cases pending there. One of them is an NRA case. And there's a number of cases percolating through the Ninth Circuit. There's 3 that are going to be heard in the Ninth Circuit next Thursday. And then there's another case that the NRA has that's moved into the Ninth Circuit, the McKay case challenging Orange County, and this Jackson case. Remember, the Jackson case was brought shortly after Heller came down, before McDonald came down. It was an in-the-home. It was intentionally brought. This was part of the strategy that I developed with a number of other attorneys with the NRA to try and sort of take a baby step. We wanted to get that standard of first the incorporation question, but then when McDonald resolved that, the Jackson case became a standard of review case, and it would have been better, if you had all the time in the world, and to have that issue resolved in the context of a case in the home, and not to have all these other issues that are now involved in the license to carry outside the home cases.
Right.
The anti-gunners are saying that the Second Amendment stops at your doorstep, essentially.
Yeah. Yeah, which is,
So,
I mean, I got to tell you, it's the right to keep and to bear
right.
arms.
And it's not just for self-defense. It's for hunting and militia service and a whole slew of other things that happen outside your house. So I'm incredulous, but it really, the judge again in the Woolard case said this best. He said that the fact that the courts are holding these ways says more about the courts than it does about the law. It's kind of disappointing to see the body of jurisprudence developing this way, where they're all just basically punting it back up to the Supreme Court, because they're paid to make tough decisions and not necessarily just err on the side of the status quo, especially when you've got an evolving, newly recognized, fundamental constitutional right. I mean, we're supposed to really respect that, and so are judges.
Absolutely.
But this case, Jackson case, is queued up. We will have it in the Ninth Circuit within a week, and all of these cases, I expect we're going to see a slew of cases seeking review in the Supreme Court after the first of the year, and depending on how the Supreme Court deals with them by the end of their term, we'll either hear them. We're probably not going to hear them until next term, but maybe we'll see. Some of these may be expedited. So it's an interesting time. But the stakes are high.
Yes.
And everybody better say a prayer at night that Justice Scalia doesn't get hit by a bus or have a heart attack, because we need all 5 of the justices that we had on the Heller and McDonald cases to stay on that court if we want to have any chance at all. Otherwise, we'll all be in the re-education camps.
Chuck Michel, thank you so much, sir, for coming on the program, and I look forward to talking to you again very soon.
My pleasure, Cam. Thanks.
Thank you, sir.